Welcome to Elite Service Masters. Are you a contractor or subcontractor looking to create solid agreements that protect your interests? You're in the right place! Today, we're diving into the 6 must-have clauses that every subcontractor contract should include for airtight agreements. From payment terms to the scope of work, these clauses can make or break your project. So, whether you're a seasoned pro or just getting started in the construction industry, this video is packed with essential tips that'll help you avoid common pitfalls and safeguard your rights. Stick around till the end to make sure your contracts are rock solid. Before we jump into the nitty-gritty, let's talk about why having a solid subcontractor contract is crucial. Imagine starting a project with high hopes, only to hit a snag because of vague terms or missing details in your contract. Disputes arise, payments get delayed, and suddenly your project is off track. Not fun, right? An airtight contract sets clear expectations, minimizes misunderstandings, and ensures that both parties are on the same page from day one. Now let's get into those 6 must-have clauses that'll keep your projects running smoothly. First up, we have payment terms. This clause is the backbone of your contract. After all, everyone wants to get paid on time, right? Clearly define how much you'll be paid, when you'll be paid, and the payment method. Consider including milestones or progress payments, especially for larger projects. This ensures cash flow and motivates both parties to keep things moving. Pro tip: include a clause for late payment penalties. This not only encourages timely payments, but also protects you from potential cash flow issues. Next, let's talk about the scope of work. This is where you outline exactly what tasks the subcontractor is responsible for. Be as detailed as possible. Ambiguous language can lead to disputes down the road. Include specifics like the materials to be used, deadlines, and any deliverables. Pro tip: avoid scope creep by specifying how any additional work request will be handled. Will there be extra charges? Will the timeline be extended? Get it in writing. The third must-have clause is indemnification. This legal term might sound intimidating, but it's basically about protecting yourself from liability. In this clause, the subcontractor agrees to cover any losses, damages, or legal fees that arise from their work. This is crucial in the construction industry, where accidents or damages can happen unexpectedly. Pro tip: make sure the indemnification clause is mutual. This means both parties agree to protect each other, creating a fair and balanced contract. Moving on to the termination clause. This clause outlines the conditions under which either party can terminate the contract. Whether it's due to poor performance, delays, or unforeseen circumstances, you need to know how to exit the agreement without landing in hot water. Pro tip: include specifics on how much notice is required and any penalties for early termination. This protects both parties and ensures a smooth transition if things don't go as planned. Next up is dispute resolution. No one likes to think about disagreements, but it's better to be prepared than caught off guard. This clause outlines how disputes will be handled, whether through mediation, arbitration, or litigation. Pro tip: opt for mediation or arbitration first. These methods are generally faster and less costly than going to court. And always specify the jurisdiction or location where disputes will be resolved. Last but not least, let's discuss insurance requirements. This clause ensures that both parties have the necessary insurance coverage to protect against potential risks. This could include general liability insurance, workers' compensation, and more, depending on the scope of the project. Pro tip: ask for proof of insurance before the project begins. This simple step can save you from a lot of headaches later on. And there you have it. 6 must-have clauses for airtight subcontractor contracts. Let's recap. 1. Payment terms. Ensure you get paid on time. 2. Scope of work. Clearly define what's expected. 3. Indemnification. Protect yourself from liability. 4. Termination clause. Know how to exit the contract if needed. 5. Dispute resolution. Handle disagreements efficiently. 6. Insurance requirements. Cover your bases with proper insurance. Remember, a well-drafted contract isn't just a formality. It's your best defense against disputes and delays. Don't leave your agreements to chance. Take the time to draft them carefully, or consult with a legal expert to make sure you're covered. If you found this video helpful, don't forget to give it a thumbs up and hit that subscribe button for more insights on contracting, construction law, and best practices in the industry. And as always, drop your questions in the comments below. We'd love to hear from you.